Today, we are digging into a legal fight that, on the surface, seems like it's just about some floor tiles. But this case, Aguas versus De Leon, is actually a fantastic window into what it really means to invent something. It shows us how patent law doesn't just protect huge, brand new creations, but also those really clever improvements. Let's get right into it. And that brings us to the big question at the heart of this entire thing. You don't have to invent the very first car to get a patent, right? But what about a better seatbelt? Or in other words, can you actually patent an improvement on something that's already out there? That's the exact question the court had to figure out. All right, so here's our roadmap for today. First up, we're going to look at the revolutionary tile that kicked this whole thing off. Then we'll see how it all ended up in a lawsuit. We'll dive deep into the courtroom arguments from both sides, reveal the final verdict, and then, most importantly, we'll talk about why this old case still really matters for innovators today. So to really get why this invention was such a big deal, you first have to understand the problem it was solving. See, back in the day, tiles were, well, they were functional, but that's about it. They were super heavy, massive things, and you could really only use them on floors. Trying to use them for decoration, especially on a wall, it was a huge pain because of their weight and bulk. And then along comes our inventor, Conrado G. de Leon. Now, he didn't invent the tile, but what he did was create what the law called a new and useful improvement in how tiles are made, and for that little bit of genius, on May 5, 1960, he was granted Philippine patent number 658. So what exactly is a patentable improvement? Well, according to the law at the time, it's not just about creating something totally new out of thin air. If you can make a real, significant, new, and useful tweak to a product or a process that already exists, that improvement can be an invention all on its own, one that's worthy of a patent. The cool thing about the Leon's invention is that it was kind of like a new recipe. Think about it. He didn't invent the ingredients, cement, sand, molds, but he figured out how to combine them in a very specific new way. He nailed down this new critical depth, as thin as 1/8 of an inch, a unique lip width to make it strong, and a special easement so the tile wouldn't crack when you took it out of the mold. And that combination gave us a tile that was light, beautifully engraved, and strong enough for walls. That was the game changer. Of course, when you have a hit product, it's not long before competition shows up. And that's where the conflict really starts, with the arrival of a guy named Domiciano A. Aguas. So let's just walk through the timeline real quick. De Leon files for his patent in late '59, and it's granted in mid-1960. By 1961, Aguas, who was a building contractor and had actually bought tiles from De Leon before, starts selling tiles that look, well, suspiciously similar. De Leon warned him to stop, got ignored, and really had no other choice. In April of 1962, he filed a lawsuit for patent infringement. And this is where we get to the real heart of the legal drama. Was De Leon's process a genuine invention? Or was Aguas just using an old technique that couldn't be patented anyway? The courtroom was about to become the stage for this debate. Okay, so let's break down the arguments. On one side, you have De Leon saying, hey, Aguas is straight up making and selling tiles using my patented invention. And he pointed to his own commercial success as proof that his idea was valuable. But Aguas came back with a really bold defense. He basically said De Leon's patent was worthless from the start. He argued the process was old news, not inventive, and that people had been doing it for years. He even tried to muddy the waters by mentioning he had his own patents, but for tile designs, not the process. And this comparison right here really shows you what was at stake. De Leon's entire argument rested on proving his tile was a true leap forward. You had the old school tiles, heavy, plain, step on the floor, and they'd break all the time. Then you have his tiles, thin, light, artistic, and tough enough to go on a wall. This contrast was absolutely key to showing his improvement was both new and useful. I mean, that's a pretty strong defense from Aguas, right? If he could just convince the court that De Leon's patent was invalid to begin with, the whole infringement case just crumbles. So the big question was, could he actually pull it off? All right, so now let's get to the verdict. And what's really fascinating isn't just who won, but the step-by-step logic the court used to get there. So before the court could even think about whether Aguas copied De Leon, it had to deal with Aguas' main challenge head-on. Was patent number 658 even valid in the first place? Was this so-called improvement a real invention? This is where a super important legal idea comes into play. You see, when a government body, like the Patent Office, with all its experts, issues a patent, the courts start with something called a presumption of validity. Basically, they assume the patent is legit unless someone can prove it's not. The burden of proof wasn't on De Leon to defend his patent. It was on Aguas to tear it down. And in the end, Aguas just couldn't do it. The court pointed out that during the trial, De Leon's lawyers challenged Aguas to produce just one single tile from anywhere made before his patent that was the same. And he couldn't. With zero concrete proof to shoot it down, the court said, yep, the patent is valid. Okay, so the patent is valid. Step 1 is done. Now the court could move on to the final, critical question: did Aguas actually infringe on it? And the answer was a big yes. The court found that the tiles Aguas was making were substantially identical in all the key ways that made De Leon's patent special: the size, the easement, the lip width, and that all-important critical depth. The similarities were just too close to be a coincidence. And of course, patent infringement comes with a price tag. The first court awarded De Leon over 10,000 pesos for what he actually lost, plus some pretty hefty damages on top of that. But check this out. When the case went to the Court of Appeals, while most of the money stayed the same, look at the moral damages. They got slashed from 50,000 pesos all the way down to just 3,000. The appeals court just didn't think that huge amount was justified. So what's the big lesson here? Beyond all the courtroom drama and the money, it really comes down to understanding the recipe for what makes an invention patentable. This case basically gives us a simple 3-step playbook. First, De Leon solved an old problem. How do you make decorative tiles that don't constantly break? Second, he did it by combining things people already knew about, but in a totally new way. And third, that special combination created a new and useful result, a whole new kind of product for a new purpose. That's the secret sauce of a patentable improvement. And that right there is the crucial takeaway. We tend to think of inventions as these massive, world-changing lightning bolts. But Aguas versus De Leon is this powerful reminder that patent law also protects and encourages those smart, small steps forward. And if you're creating things today, that's a huge strategic insight. You don't always have to reinvent the wheel. Sometimes making that wheel just a little bit lighter, stronger, or better is the most valuable invention of all. So I'll leave you with this thought to chew on. Just look at the world around you. That slight curve on your phone that makes it fit your hand better, the special cap on a drink that's just a little easier to open. What everyday improvement that you probably take for granted could actually be an invention hiding in plain sight?